A major piece of litigation may be many things. It may be complex law, it may be a very significant organisational exercise, but most likely it will also be a game of chance. And it's a game of chance with very significant consequences, both in terms of the legal costs and also the outcomes of the litigation. In this video, we look at how we think those chances can be most properly assessed.
Litigation is inherently risky, and the most obvious risk is uncertainty in relation to the outcome of the overall case. Should it go to trial, and should you get a final and binding judgment? And in that context, one often thinks of one party winning, another party losing, but litigation is usually a non-zero-sum game. So that means one party's gains won't necessarily be matched or reflected in the other party's losses, and it's much more nuanced than that. So you need to take into account a range of risks in assessing your strategy. One approach is to focus purely on risk in relation to the legal arguments, perhaps getting an opinion on the merits of success in relation to those arguments, either as part of an early case assessment or perhaps a little bit later with the involvement of counsel. But that's not the only risk. There are plenty of other risks, including risk in relation to documents, witnesses, also understanding that just because somebody says that there's a percentage prospects of success, you're not necessarily going to find out the answer as to whether you're right or not until the end of the case, which is many years later after the costs and time that's been expended. So it's a much more nuanced approach and needs some careful thought and consideration.
Witnesses can be a crucial area in assessing the risks of litigation.
Certainly when you think of a big trial, you think of the witness in the stand before the court being cross-examined by a very clever barrister who trips them up about something, and then there are gasps from the audience that this has been revealed. In reality, witness evidence often plays a very different role to that, and we shouldn't get it out of perspective. But for factual disputes, it can be very important to the analysis of risk. In order to look at the risks associated with witnesses, I would start by looking at the scope of the witness evidence that's actually needed. It can be very tempting to think that you need evidence on every single issue, but in fact, you really only need evidence on the issues which are factual and in dispute. So there may be many factual issues which can be perfectly easily settled through documents, and similarly there may be many legal issues which don't need to come within the purview of witnesses at all. And so once you've then established that scope of the witness evidence, you can think about who are the individuals who would be able to speak to those issues. Obviously, it doesn't need to be one individual for all of them. It might be split between a number of individuals. So what's your potential pool of individuals available to do that? And how credible and likeable are the individuals who fall within that pool? Human nature is such that the extent to which you like or dislike somebody is likely to impact on how credible you think you are, and unfortunately, judges are not immune to that sort of analysis in terms of reaching a conclusion as to who is the witness that is most credible and whose case should be successful as a result of that.
So witnesses clearly present a high risk in any piece of litigation, and I would break down that risk into two areas. The first one, clearly you can't do anything about, which is that their facts simply don't support the case that you're making. But the second one you can do something about, and that is their performance as a witness. So we're human, we're going to a high pressure, high stakes environment, you have sort of particular fact pattern, and you want them to be able to communicate that fact pattern in a way that is credible and reliable. And our performance, there's a lot of performance factors that will impact how you come across as a witness. So assessing the likelihood of a witness performing well isn't easy, and I distinguish between a witness performing well and a strong performance. I think there are a lot of strong witnesses who would not necessarily perform well, and it's the performance that we're interested in. I would break that down into three areas. The first one being knowledge. Knowledge is easy to instill, but it's hard to remember how if you haven't done something before and you're walking into a new environment, that things that are very normal and everyday to you may be very new to someone else. And we all have a natural fear of the unknown. So helping build that knowledge for all witnesses is critical. The second area is experience, and knowing how experienced someone is as a witness is going to make a big difference. Now, there's nuances to that, because in most cases, people won't have had experience of being a witness. If they had, clearly you can ask that question and you can ask them about how that experience was and how they performed. But in the likely event they haven't, then you can explore whether they've had experience in similar situations. So have they performed under pressure? But the closer we get that performance to actually giving evidence, then the better. And the more you reduce the risk by understanding they've got similar experience. And the third area is probably the hardest, because it's more trainable and it's more variable, is their skills. So in some cases, there are some personality case types that I think could be useful. So I'd say you want a witness who isn't too argumentative, that is concise, that's precise, that doesn't overly justify, and that doesn't talk too much. But overriding that, I think there's two fundamental skills for a witness that would help more so than their kind of personality type. And I think the first one is their ability to accept and understand their role. The role of a witness isn't to be an advocate, it's not to win their case, it's not to argue with the opposing barrister. And when you've got a lot at stake and you're under pressure, it's quite hard to accept that role and to let go of control and to just trust your legal team. And I think the second one is, in simple terms, the ability to focus. And by focus, I mean the ability to shut out the noise around them. So fundamentally, from a psychology point of view, being a witness is about listening to and answering the question and ignoring everything else that sits around that. And there's a lot that sits around that can be very distracting. So you can be focused on the formality of the courtroom. You can be focused on the proximity of the barrister cross-examining you, the leading questions, the implications of the questions that they're asking you. You can be focused on the stakes and the outcome of the case. You can be focused on whether you're going to be giving evidence overnight or over the weekend and be in purdah. But all of that is a distraction from your one job to listen to and answer the question.
So what else comes into play when assessing the risks of litigation? Well, documents are crucial.
Documents often loom large in litigation. That's because now in the electronic world, we've got the spectre of very expensive and timely disclosure exercises. But actually, how documents are used in litigation and the genuine risk benefit that comes from them is generally much more nuanced than that, because it's rare for you to come up with that smoking gun document. If we're thinking about the risk that arises from documents, I'd be thinking about what documents do we know of that our party holds, but then also what do we know of what the other party holds? Where does the balance of knowledge lie there? And is there anything that we can do in order to shift that balance so that we have greater visibility of the documents, both so that we can assess the risk, but also so that we can design the litigation strategy around it? The process that I'd carry out in relation to documents in advance of starting the litigation would all be about proportionality. So in some cases where there's a significant factual dispute and the overall dispute is worth a lot of money, it really is going to be worth spending time, energy, and most importantly money to undertake quite a significant exercise to assess the merits and to make sure that you can put your best foot forward. For smaller cases and for cases which turn much more squarely on legal principles, then that's not going to be proportionate and appropriate. And you have to look at all of the different levers in that in order to determine that. And that's all part of your risk-benefit analysis.
As important as your factual evidence, your documents, your witnesses are, another very important area is the legal position.
No matter how wronged you might feel as a result of what someone else might have done, you have to, of course, establish a legal basis for your claim. Now, that might be a breach in contract, it might be a breach of statute, or it might be a tortious claim, something in negligence or defamation. Now, we're rightly proud in this country of our 900-year history of the legal system here, with the independence and quality of our judiciary and the relative certainty that English law legal principles provide. But that notwithstanding, there will be instances where there may be legal uncertainties in your case, and it's important to try and identify those at the outset, because that might inform your case strategy. It might only have a small impact on, for example, a part of the quantum you might be seeking in terms of your loss. Alternatively, it might affect the whole strategy in terms of your pleading and the relevant parts of the law that you might want to set out in your particulars of claim. So it's a really important thing to consider with your legal team at the outset, and it's important to keep it under review. It changes all the time. These discrepancies could happen for a number of reasons, for example, conflicting case law or changes in statute, or maybe even a lacuna in the law depending on what your case is about and its specific facts.
Ultimately, any piece of litigation will be decided by a judge. A judge is a human being, it's a human process, and that gives rise to a degree of uncertainty in itself.
Where a case proceeds all the way to trial, you do get instances, or I do, of clients asking me, to what extent will the judge impact the case and what, if anything, can we do about that? And the reality is we have very little understanding of how judges are assigned to cases, and it could be due to their availability, their interests, or even frankly who's next in line. Sometimes the judge themselves, if they have a particular interest in that area, might volunteer themselves for a particular case. And ultimately you have very little influence over which judge hears your case. Now, you can do certain things to direct it. So, for example, you could choose to bring your case in a particular court, in which case, if it's a specialist court, you've narrowed the pool of judges that are likely to hear your case. And in instances where, for example, you've had a particular judge for an interlocutory hearing at the start of your case, it is possible to get that judge what's called docketed to your case. So the same judge should then ideally hear all of the future hearings, including and up to trial. Well, one risk that clients are often worried about is whether the person that's given the responsibility of dealing with their case has the necessary expertise to handle it and to understand what's going on. In particular, if they're in a particular industry, for example, or if they think that there's a certain technical area that the person deciding their case, whether that's a judge or someone else, needs to have in order to make a decision. Now, in court, obviously, judges are experts in their own right, but they can also ask experts to give expert evidence to help them make the judgments at the end of the trial. An alternative to that is to suggest to clients, well, at the outset, think about it in your contract where you're already deciding your relationship with the other side, whether they want litigation or whether, in fact, they should go to arbitration. Arbitration is another form of dispute resolution that allows parties a bit more flexibility in terms of how the arbitration is run. You can choose the rules that might apply, but also who is responsible for hearing your case. You can choose at the outset in your contract to specify certain characteristics that you want the arbitrator to have, for example, certain sort of areas of expertise. Or alternatively, if for example, it's a 3-arbitrator tribunal, when you're nominating your arbitrator, you can choose someone at that point in time that you think has the relevant technical expertise for the specific dispute that's arisen.
Another important risk factor in practice in litigation is the question of enforcement.
I think it's important to bear in mind what success is in litigation. It's often easy to think of success as getting a judgment in your favour, but in fact, in most cases, success needs to be looked at in terms of getting that judgment and enforcing that judgment in your favour. And so all too often, parties are very focused on making sure that they get the successful judgment and don't, in advance or during the course of the litigation, give enough thought to how that would be enforced and whether it will be enforceable. But it's absolutely critical to your cost-benefit analysis whether you're going to be able to enforce the financial aspect. Of course, there will be rare cases where the enforcement of a financial aspect is less important. So, for example, defamation proceedings, a judgment exonerating you may be considered enough. That might be success for you. But it's just about really understanding for the cost-benefit analysis, what's the end game, what does success look like, and making sure you've considered all of the steps to it, up to and including enforcement, if you're in one of the usual cases where getting financial recompense for your costs and damages is important.
The X factor in any litigation is the question of settlement. A settlement may give you everything you're looking for without having to go all the way to trial and judgment, but it's something that needs to be carefully considered right at the outset.
The ultimate way to mitigate risk is, of course, to seek to negotiate a resolution of the dispute through a settlement, thereby taking the decision-making process out of the hands of a judge or arbitral tribunal. And it's important to consider settlement at an early stage and to understand what your parameters of settlement are, what are the critical things that matter to you, what matters to your opponent, what are the red lines, perceived or otherwise, and what are the bottom line below which you just won't cross, as well as other factors such as what's the best or worst alternative to a negotiated agreement, a BATNA or whatnot. And that will help you assess and formulate your position and your settlement strategy, as well as taking into account other factors such as reputational risk and of course the time and cost of litigation. Now, for the most complex of cases, there's really some cutting edge thinking behind this approach, including some very sophisticated modelling that helps inform the decisions that you may or may not make, and I'll be touching on that in a separate video.